Court does call the case of the people versus Daniel Magoo. State your name.
Daniel Magoo.
All right. What are we doing on this today?
Your Honor, I have in regards to case number 25F4-523, I have a couple things I'd like to point out about a couple of the matters here today.
Go ahead.
In regards to count 3, MCL 750197, lawfully detained or imprisoned in jail or confinement. Judging by the definition of the statute itself, Your Honor, it compels us to conclude that one has to be lawfully imprisoned or in jail. Jail being a facility operated by a local unit of government for detention of persons charged. At this location, defendant was located in a hospital and not a confinement by government agency or jail. So I'm requesting that charge is invalid on its face.
To be addressed, that would be addressed at the preliminary examination, sir, as to the sufficiency of the charge. So if you're making a motion that I dismiss it at this point, that motion is denied.
Okay. Further, in count 2 and count 1, actually, Your Honor, both of these were, I don't know the procedural process or when it should get raised, but both of them are Fourth Amendment violations. And furthermore, on count 2, MCL 257.904, that the license of the defendant was revoked or suspended, given the statute as well, Your Honor. That would require the prosecutor to prove that the license was revoked or suspended at the time of the arrest, and that defendant was notified, and that the defendant operated a vehicle on a highway or roadway. I challenged the prosecutor to prove all 3.
Sir,
Yes,
do you wish to have a preliminary examination in this?
I'm making sure we're prepared for it, but yes.
What'd you say?
Making sure we're prepared for it, but yes, I am. What are the other options? I'm requesting that all the charges are dismissed, a motion for all dismissal on all these charges.
Well, would you look at that? He actually did something sensible for a change. Maybe he's not as clueless as everyone assumed, even if that haircut still makes you pause. It's refreshing to see him take a step that actually shows some thought and judgment. Perhaps he's starting to turn things around, and this could be the first of more practical decisions. Let's hope he continues on this path and keeps making choices that make sense.
They're not going to be dismissed.
No, okay.
So if you want a preliminary examination and make your arguments, then it might be that they would be dismissed at that point, but they're not going to be dismissed on an oral motion before this.
Ms. Lobby has let me know that all paper discovery has been sent to Mr. Magoo in jail. There are USB drives with video. A number of agencies were involved in the Michigan State Police case, so they responded to assist. I believe she has obtained all of those videos, and those will be sent interdepartmental to jail staff to serve on Mr. Magoo, and I expect those to be in the interdepartmental mail tomorrow.
Got it. Okay, so we're not ready. He hasn't gotten the video.
He has all paper discovery, but he does not have all video discovery. I expect that'll happen. So I'm not sure yet.
So, Mr. Magoo, are you going to have an objection to an adjournment so that you can see all of the discovery that they have prior to setting this for preliminary examination?
Your Honor, I didn't know what hearing I was prepared for today. I was preparing to cross-examine the officers today, with or without the video evidence. So, given that that's not the case and the officers are not here, I would like a speedy trial. I would like to invoke my right to a
All right.
speedy trial.
So you want your preliminary examination. Those are coming down to the jail to him.
I expect that you would have them early next week, so if the court follows its normal setting for preliminary examination, I would expect.
I would set it for the 19th, and then
have them well.
he'd have them well in advance, and I guess I'll do it that way. Prior to setting the preliminary examination, it's being a critical process, a couple of things that the court wants to do. Mr. Magoo, starting in case ending in 0979. Mr. Magoo, you are before the court on a felony complaint that alleges 5 different counts, including an eluding 4th degree, which is a felony punishable by up to 2 incarceration, $2,000 fine plus court costs. Count 2 is operating an unregistered vehicle, which is a misdemeanor, punishable by up to 90 days. Operating without security, which is a misdemeanor, punishable with not more than 1 year or less than a $200 nor more than $500 fine plus court costs. Count 4, operating while license suspended, denied, and or revoked. That is a misdemeanor, punishable by up to 93 days. $500 fine plus court costs, and your vehicle would be subject to mobilization. Count 5 is refusal to obey a lawful traffic order of a police officer. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. Those events are alleged to have occurred on July 3rd, 2025, I-94 near Parker Road in Scioto Township. That is on the one case. On the other case, which is a 3-count complaint, that 3-count complaint alleges that on March 27, 2024, location of Dexter near Arcona in the city of Milan, Washtenaw County, state of Michigan, that you did operate a motor vehicle while intoxicated. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. There is, however, a third offense notice which transforms this into a felony charge. It's punishable by up to $500 to $5,000 fine plus court costs, 1 to 5 years in jail, probation with 30 days or 1 year in jail, or at least 48 hours to be served consecutively, and 60 to 180 days community service, any rehabilitative programs the court deems necessary. The court could order you to pay the cost of the prosecution, the cost of any emergency governmental services, and your vehicle would be subject to mobilization. Count 2 is operating while your driver's license was suspended, denied, and or revoked. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Count 3 is lawful escape from custody, or escape from lawful custody, That's a misdemeanor, punishable by up to 1 year, $1,000 fine plus court costs. Mr. Magoo, I would just ask, do you still wish on representing yourself, sir?
Your Honor, I do. I will. I have requested assistance, given that I am incarcerated and I have no way to.
Do you wish to be represented by an attorney, sir?
I would like legal assistance.
What do you mean by that? Would you like to be represented by?
I've called the
Mr.
prosecutor.
Magoo, we go through this every time. So here's what I'm going to do. I'm going to advise you that there are great perils in representing oneself. I've told you about that before on numerous occasions. That I would treat you the same as I would treat anybody else. You would have to know the Michigan court rules. You'd have to know courtroom procedure, and that you would be treated the same, not any more favorably, not any worse, as you would go through these proceedings. If you wish to represent yourself, you may proceed with the court's admonishment. I've advised you as to the penalty, the charges, the maximum penalties. I will now ask you the question, and I'm not going to just keep going around and around in circles when I ask you this question. Do you wish to be represented by counsel? If you wish to be represented by counsel, this court will ensure that counsel is appointed to represent you. If that is a yes or no.
I would like legal assistance, yes, Your Honor.
These charges aren't minor anymore, since this would be your 3rd DUI. the situation is now very serious. If the court rules against you, the charge could be upgraded to a felony, which carries far harsher consequences than anything you've dealt with before. This isn't a matter to take lightly or ignore. Every choice you make in this case counts, and the outcome could have a lasting impact on your life. It's crucial to approach this carefully and understand just how high the stakes really are.
I'm going to take that as your request for count, is how I'm going to take that. And so these two cases now become public defender cases.
Thank you, Judge. Torture Feaster, Assistant Public Defender on behalf of the defendant. I believe Your Honor has already agreed to set it for examination.
I will set, he's asked for examination in the case, and so I will set these for preliminary examination.
Okay.
Well, Your Honor, I would ask, given that one of these cases, in regards to the March 27, 2024 case, there is an undue delay. It's been over, I think, 390 some days since the warrant was requested, and this triggers due process violations under U.S. versus Levasco, People versus Bassard, People versus Rosengreen, and procedural unfairness, Sixth Amendment violations. And I do request that the prosecutor provide provide information in regards to the three-pronged test under People versus Hernandez. One of them, first test being the explanation for the undue delay for 390 some days. The second part of that test being to prove that the delay was not deliberate. And then the third part of the delay or the prong test is to make sure that there was no undue burden on or prejudice on the defendant. And in that regards, Your Honor, I also am requesting that I do have due process 14th Amendment rights as well as 8th Amendment rights. And a lot of these are facially invalid. A lot of these charges are facially invalid. And I'm just requesting that the court grant a personal reconnaissance on my behalf. And for both of these charges, being that we're looking at really just misdemeanors, $500 misdemeanors. So
that wraps up this hearing. It's obvious that Dan Magku won't be getting out of custody anytime soon, giving him the weekend to think over his actions and any legal steps he might consider next. Perhaps this pause will give him a chance to reconsider the choices that led him here. Now, we move on to the next case. This one involves a woman who has been repeatedly troubling her neighbor, both online and in person. Yet she is asking the court to lift the protective order that was put in place. The situation is tense, and it will be interesting to see how the court handles it and what decisions are.
I think he's requesting, Your Honor, amend his bond, and he's requesting the release, Your Honor, PR bond.
In response from the people regarding his bond.
People would ask the bond to continue, and he also failed to appear before Judge Slade's. So
yes.
That warrant would also, with respect to the other I'll wait. If there are pleadings filed by the defender's office, will respond to that. And I guess my one remaining point would be, with the court's appointment to the public defender's office, I will make sure that the digital discovery that I referenced is served on the public defender's office.
Yes.
Thank you, Judge. We will review that with our client once we receive it.
So he's asked for a preliminary examination, and I realize where this may be. My understanding is that he is still held, regardless of what the bond would. In this case, he's being held without bond in Judge Slade's case.
That's my understanding.
That his bond has been denied. So
that's what I would Mr. Choda said.
In any event, but also given the fact that one of the charges is the escape from lawful custody, that in and of itself, in this court's mind, makes the defendant a danger for a risk of flight. Also, the nature of the charges, the fleeing and eluding, police officers, as well as the operating while intoxicated, now at least alleged his third time around. Also, this court's mind, the defendant, this court would consider a danger to the public. So the extent that he is asking that I modify his bond conditions in his bond in this case,
I have,
that motion is denied. Bond will continue as it is.
Your Honor, I have a 14th Amendment due process to the presumption.
Hurling eggs at your neighbor's house is never a wise choice, and bringing your child into it only makes things worse. To make matters even clearer, the neighbor has security cameras, so everything is caught on tape. Considering how much eggs cost these days, you're essentially wasting money for no reason. This kind of action just stirs up unnecessary trouble that could easily be avoided. In the long run, there are far smarter and safer ways to handle a disagreement than doing something that only causes more problems.
Not a jail.
If you were under the custody of the Washtenaw County Sheriff's
I was
Office,
not.
I understand.
I was not.
Or custody of.
I was dropped off at the hospital and they later tacked on
And
charges
you know
just
what?
like the fleeing and
evidence
eluding
will
charge.
Not meet that out, and that if that's true, and the people can't sustain that element, then the charge will be dismissed. But I'm not dismissing it upon your representation today.
There are a few key points to consider here. First, the protective order appears to be doing its job, so it's understandable why she wants it extended. At the same time, a protective order restricts someone's rights, including their freedom of movement, so the court needs strong reasons before it can approve an extension. She claims to have video evidence to support her request, but she wasn't able to present it in court today. Without that proof, it's much harder for the judge to make a confident decision. What happens next will likely depend on when she submits that evidence and how convincing it is.
Thank you very much, Judge.
Preliminary examination in this matter will be set August 19th, 2025, 12 noon. That is before me. On that date for both of these cases. I will apprise the parties also that one of the, I will call it one of the activities, and I think it is a maneuver to have the court do something that it normally would not do. The defendant has elected, and I will disclose it, to file a civil claim as against me and a slew of other parties.
Oh yeah, in that regard, Your Honor,
Many of those, do not interrupt me. Including many that I don't even know the connection. Court has, this judge, upon receiving this, two things. I read through the complaint to determine whether or not it would on its face create a conflict with the court. I consider it, quite frankly, to be frivolous. The complaint itself, do not see that as a necessity for me to recuse myself from this gentleman's proceedings, because I think that's precisely what he wants to have happen, and that is attempting to manipulate the system. He will be dealt with by me as I would deal with any other defendant, and so that is there. It has been turned over to the Office of General Counsel for the Washtenaw County. They will deal with, for me, and as well as the others that I see that are listed there, they will deal with that. They have also filed, it appears, and again, this is all part of his, what I will call shenanigans to shape this. He has filed against people of individuals without specific reference in the Washtenaw County Prosecutor's Office. I don't, as I view what I read, would not consider that any jeopardy upon their objectivity in handling this case. So,
I'm aware of such filings were being received by our office maybe yesterday. At this point, we continue to proceed with this case until I did otherwise from the elected prosecutor.
Can I speak on that note, Your Honor?
I will let you talk, but I'm not going to let you go on in some diatribe. I've got other things to do.
I've stood on my rights and I've stood on my beliefs this whole entire time, especially in the previous case, Your Honor. That complaint is well pleaded. It does affect multiple parties of this jurisdiction. Washtenaw County is a named party, and I do believe that my impartiality and bias will be affected here, as it was in the past before this complaint. And I do request a change of venue on that note for both these matters.
If you wish to raise change of venue, you may file that in writing, but to the extent you are raising no motion for change of venue, denied.
Thank you very much, Judge.
Bond will continue. Thank you.
That wraps up this hearing for now. The victim will have an opportunity to present her evidence, and at the next session, the court will decide whether the protective order should stay in place or be lifted. The outcome will largely depend on what she can show the judge and how convincing her case is. Next, we move on to another case, and this one comes with its own challenges. The defendant repeatedly interrupts at the wrong times and even shows disrespect toward the person who is there to help him, his own attorney. This behavior is creating a tense atmosphere in the courtroom. How he handles himself from here will reveal a lot about how seriously he is approaching his own case and whether he's willing to follow the proper procedures.
We are here in the case of Darnell Gay versus Renee Campbell, case number 25-05147PH. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court today on Ms. Campbell's request to terminate the personal protective order that I granted in favor of Ms. Gay back on June 14th of 2025. I do have to tell you, both ladies, and apologize in advance. I have gotten us behind just through my fault and my failure to move these cases as fast as I'm supposed to move them this afternoon. So I'm a little bit short on time. I don't have time to take extensive testimony on it. I think what I'd like to do is let me see here. Okay, so we're just going to have to keep it quite short. And I guess the way I'll do it is I'll swear in Ms. Gay, take her testimony as to the basis for the PPO. I will hear in a response from Ms. Campbell why I should terminate the PPO, and then I can make a ruling. So, Ms. Gay, if you would please raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
I do.
Very good. And to support this protective order, you stated that there were a couple of incidents here, one of them being Ms. Campbell throwing eggs at your house. Tell me what happened on that occasion.
After the incident happened, after the altercation with, her and everybody else on the Hall Street,
Yes.
They threw eggs at my home.
Was
and
it
then
during that same big brouhaha on the blow up, or was it later that day or in the evening? When did it happen?
later.
Okay.
And
All right.
then
And who were the egg throwers that you saw?
Renee and her daughter.
And you saw them actually throw eggs at your house?
Yes, because the next day she was on the neighbor's porch, just keep yelling. I didn't throw eggs. I have cameras all around my home, all around it. And I have my cameras, if you come anywhere towards my perimeter of my property, it captures you. It was her and her daughter. They were throwing eggs. And then the next day she was on the neighbors on their porch, just constantly yelling at my house. I've never had a conversation with her yelling. I haven't thrown eggs.
The prosecution followed the correct procedures under Michigan law when serving you. Simply saying you didn't receive the paperwork doesn't change the fact that the service was done properly. In cases like this, the court places far more weight on the officer's official documentation than on someone who seems to be avoiding the process. It's a strong reminder that staying on top of responsibilities, like paying rent or responding to notices, can prevent a lot of unnecessary trouble down the line. That wraps up today's video. If you found it helpful, go ahead and hit the like button. If not, feel free to hit dislike. But either way, leave a comment to share your thoughts. Don't forget to subscribe and turn on notifications so you never miss future updates. I'm Team Skeptic, and I'll see you in the next video.